Foreclosures Section 2, Mortgage Default. Failure to make mortgage payments as required is called mortgage default. Under a mortgage contract, failing to meet those payments allows the lenders to take legal action to protect their security. As soon as the borrowers realize they're in financial difficulty, the best thing they can do is inform the lender in writing that they are unable to make the payments and that they would like to make arrangements to have a borrower assessment as an attempt to save the loan. The lender has save a loan procedures in place to help people in financial predicaments. During the borrower assessment, the lender will ask why the debtor is incapable of paying. Perhaps income has been reduced, there are marital problems, or they are not working due to a strike, illness, death in the family, or more commonly, they have simply mismanaged their money. If the lender sees the problem is short-term, different solutions are often arranged to help with a recovery plan. It's important to make these arrangements right away because a mortgage that has not been paid for 3 months is likely not to be saved. Perhaps arrangements may be made to have the payments reduced, called partial deferral of the mortgage payment for a short time, or perhaps interest-only payments can be made. Sometimes, if it is just 1 or 2 payments, as in a strike situation, the borrower's actual payments can be added onto the end of the mortgage period. Being proactive in taking early intervention action is worthwhile. Contacting the lender even before the first payment is overdue is the best thing for the borrowers to do. The lender can take other steps to assist the borrowers. A permanent solution could be to extend the amortization period of the mortgage, which was lessen the monthly payments. If the current interest rates are lower, refinancing may be the answer. The amortization can be maximized to 35 years from the original date of the loan. However, this requires approval from the lender mortgage insurer. Another approach would be to add the arrears to the outstanding principal for the life of the loan. This is usually done when the borrowers are able to pay, but do not have the ability to repay the arrears. This is allowed only once for the borrowers. At worst, if the payments cannot be made at all, the lender can seek judgment against the borrowers for the amounts in arrears. Included in these costs may be legal fees, interest incurred, and even prepayment penalties. Borrowers will be liable personally for these costs. The borrower's assignment in bankruptcy will affect whether the lender can seek judgment against the borrowers or not. If there are tenants in place, the lender may choose to appoint a receiver to obtain an assignment of rents. The borrowers can apply for the Orderly Payment of Debts program, which is administered by the provincial government under the Bankruptcy and Insolvency Act. This is a debt pooling plan, but because the loan is secured with real property, the lender still has the right to foreclose on the property. According to law, there is a redemption period granted by the court. It can vary from 6 months to 1 day, according to the owner's equity and the condition of the property. This amount of time can be shortened if there is evidence that the security of the loan is in jeopardy. The courts may make an immediate final order of foreclosure if it is proven that there is no equity in the property and the amounts owing are more than the market value of the property. Abandonment of the property is another reason why the courts may expedite the order. Evidence that the security is at risk, such as someone canceling the home insurance, non-payment of taxes, and waste occurring, something that destroys the property, will also be reasons for court to shorten the redemption period. Judgments. A judgment in law is a final written order or decision made by the court. The document, once drawn up, becomes a record of the court's decision and specifies the amount of any damages owing. An order can be made awarding regular installments of a certain amount of money from the debtors, or the judgment can be registered in the land title office as the charge or lien against the person's land under the BC Court Order Enforcement Act. The person collecting the money can have the property sold in order to pay the judgment amount by making an application to the court for a judicial sale of the land. There are very specific rules of court in foreclosure proceedings that must be followed. If a deficiency results because the property was worth less than the amount owed under the mortgage, a judgment would result against the debtors by way of the personal covenant. Alternatively, if the judgment debtors have assessments, they can be seized and sold. The judgment can be attached to other property owned by the debtors, such as a car or boat, which can then be seized and sold to pay the debt. A judgment registered in the land title office against the real property must be renewed every second year. Action against the debtor's personal covenant. The lender has legal rights against the property and also against the parties to the covenant. A legal term for rights against a person is in personam. These rights are enforced through the court by judgment. The parties' property may be sold, or an order may be made requiring the debtors to make payments in satisfaction of the judgment's personal bankruptcy. Definition and effect. Bankruptcy is a remedy for persons who are unable to meet their financial obligations as they come due. A person in such a situation may make an assignment in bankruptcy at any time by meeting with the trustee, completing the appropriate application forms, and then filing them in the bankruptcy registry, which is located at any Supreme Court registry in the province. The immediate effect of making an assignment in bankruptcy is that all actions against the bankrupt are stayed. This means that any action in progress cannot proceed while the individual remains bankrupt. An order of a court or leave of a trustee is required in order for the action to proceed. Typically, a bankruptcy lasts 9 months, and then the person is discharged, usually by court order, in a hearing which is not opposed. If there is opposition, the discharge may be delayed or given on certain conditions. Lender's notice of intention to enforce. In foreclosure actions, lenders may, before launching action, send the mortgagor borrower a document known as the Notice of Intention to Enforce Security. This document, if delivered to the mortgagor, allows a foreclosure action to proceed notwithstanding a bankruptcy, remaining in the property. It is not unusual for a person to make an assignment in bankruptcy but remain in his or her property. Such individuals may even make mortgage payments while in bankruptcy depending on their circumstances. There is case law suggesting that if a foreclosure is launched against a bankruptcy in such circumstances, the bankruptcy does not bar a lender from seeking judgment against the borrower in the foreclosure action. Simply put, an intention to remain in a property after a bankruptcy suggests that the debtor wants to continue making the mortgage payments, and so the bankruptcy will not eliminate the legal responsibility for the debt under the personal covenant of the mortgage. Exemptions. When a person makes an assignment in bankruptcy, they are permitted to retain a portion, a portion of any equity in their residential property. If there is enough equity, a person can claim the first $12,000 of equity in their home. If the person is married or lives in a marriage-like relationship in the home, the couple can, if they both make an assignment, retain $24,000 in equity. There are other exemptions including personal effects, tools used in work, clothing, medical aids, and a vehicle with a modest value. There are certain debts that are not eliminated by bankruptcy. These include child and spousal support, secured debts such as a debt owing on a motor vehicle secured by security interest, court-ordered fines, student loans, and any amounts owing to Canada Employment and Immigration for EI overpayments. Bankruptcy can be expensive. Trustee fees and filing fees are generally significant. The cost of a standard bankruptcy assignment will be not less than $1,200. It can also be a lot higher depending upon the circumstances. Realtor's work. A realtor's work may be affected by bankruptcy. If the assignment in bankruptcy is made after the foreclosure action is launched, the action could be halted or stayed. In such a case, marketing efforts will have to be at least temporarily stopped. If there is no notice of intention to enforce delivered to the mortgagor, it is possible that the action will be struck and have to be started over. If the assignment is made before the action is launched, likely the lender will deliver a note of intention to enforce so that the action may be launched. It could be very important for a lender if it was unable to proceed with an action. A potential deficiency might be increased and the ability to force a move out of the property in poor condition might be blocked. Owner's interest upon bankruptcy. An assignment in bankruptcy immediately eliminates the mortgagor's interest in the property. Title can be moved immediately to the trustee, subject to the exemptions referred to above. Thus, a title search by the lender will reveal whether the trustee has taken title to the property, which will affect the foreclosure action. All dealings will have to be conducted through the trustee given that it takes the title. Through the trustee given that it takes the title. If a trustee chooses not to take the title, it is because it is believed that there is little or no equity. A trustee will usually not take an interest in a foreclosure where there is believed to be little or no equity in the property for the bankrupt. The trustee will simply allow the foreclosure to proceed without its opposition. If the bankrupts are spouses married or in a marriage-like relationship, the rules of bankruptcy obviously apply to them both. However, if only one spouse makes an assignment and the other spouse is not relieved from responsibility under the mortgage. Mortgage liability for spouses is often joint and several. This means that the lender may pursue either spouse or both spouses for the entire debt. If one spouse is bankrupt, then the other will retain legal responsibility for the entire debt. Another method of handling financial insolvency is the application for a consolidation order. This is a court order and allows the applicant to make one regular payment, usually monthly, in respect of his or her debts. The payments are made to the court. The court then distributes the payments to creditors. In such an arrangement, the borrower does not lose their assets. Payments are usually made over a 3-year period. Interest is charged at 5% per annum. The borrower here does not lose their assets, therefore, a lender may proceed with a foreclosure action in such circumstances. If a realtor has information that a borrower is bankrupt, the realtor should advise his or her client immediately. It should not be assumed by a realtor that a lender knows a borrower is bankrupt. The lender may or may not know of a bankruptcy. Farmland. There is a Farm Debt Mediation Act, which provides mediation between insolvent farmers and their creditors. When farmers cease to pay their current obligations as they become due, administrators will be appointed. The farmer can apply for either a stay of proceedings by all of the credits or apply for a review of their financial affairs and ask for mediation with the purpose of reaching an arrangement. Foreclosure of farmland is complicated and requires lawyers, mediators, and the service of experts. Additional information can be found in the Federal Bankruptcy and Insolvency Act. And that's the end of Section 2.